So let's get started into the screen share here. So I have, you can't see the client information. That's to protect the innocent here. But I want to go over this and tell you that this is what is going to happen to your divorce case, most likely. Some scenario of this, the people that call me to take over their case has some issue like this. This is one of the worst ones that I've seen in a while. And I'm going to go over this. Hopefully you see my cursor and explain to you what these issues are here. So I want to say I'm like Neo in the Matrix, if you've seen that, where when you call me and you have a filed case, when you schedule a consultation, I ask what your case number is. So when I have the call, I can have already reviewed your case summary. So this is all I see. I don't see your images. I don't see the specific information, but I do see what's been filed. So as you can see, I just see the date and what the document was that was filed. There's no names on here, so you don't have to worry about that. So what I can see prior to the call was they filed the petition on June 30th, 2022. This is just the forms that go along with it, summons, case cover sheet. So we already know there's no children, and these are the 4 forms that get filed for LA County. They also filed the fee waiver at the time and the proof of service. So this is where normally people will get to that call me to take over the case. They've done the initial filing, they've served it, and then they'll call me. But some people, the other half that have started their own divorce, will try and go all the way through to the judgment phase. So what I can see here is, again, they filed and served. The petitioner did their declaration of service, declaration disclosure. And then there's this then they tried to file the request for default and it got rejected. And how do I know that? Because they tried to file it again. And then the weirdest thing I've ever seen is they filed an amended summons. You cannot file an amended summons without filing the amended petition. And then they try to turn their default again, along with a judgment package. And after talking to them, this was rejected again, and the entire judgment package was rejected on 2 days ago. And then they set up this call, and I went over this. So without ever even looking at their paperwork, I can tell you exactly what's going to have to happen here. And let me explain what that is. We have to completely start over, because in speaking with them, there were some names mixed up or misspelled in the summons and petition, which was the issue here, which happens a lot. They served it, which is the good news, because we don't have to restart the 6 months, but we do have to refile because they filed this amended summons without the amended petition. This is now taking this initial filing's place. So what we're going to do is, when they hire me, we have to start from scratch. I have to file another amended summons and petition, which then has to be reserved. And then we have to wait the 31 days, and then we can file the default with agreement type divorce case. They are in agreement. They're trying to get through the divorce. They're just having trouble with the procedural nightmare of getting through a divorce can be. So again, they are agreeable and they're having all this trouble. 2022 divorce case. Talk about this all the time. 2020 cases, 19 cases, 10 years old, 20-year-old cases. Those folks didn't know that they weren't divorced, but this is usually what happens. And then people get frustrated and they just stop, which is what they said happened. Because you can see there's no activity from July 13th until April 4th of this year, and they're picking it back up. This default was rejected because not only because they filed this amended petition, but that's definitely a reason, but because of the errors that were in the initial filing in 2022. So the correction will be starting from scratch, amending the summons and petition, refiling, reserving, waiting the 31 days, and then turning in their default with agreement, settlement agreement, divorce case. The other issue was the consultation I had was with the respondent, and she thought there was nothing she could do because she hadn't responded to assist with the case. And they were treating this as a default without a written agreement. And I see this so often. And how do I know they're treating this as a default without agreement? Is because it says judgment package received, FC 2336, which that shouldn't be on there. That means that they checked that box on the 180. That's wrong. But if it was a settlement agreement, it would have said stipulated, and it's not. The other indicator that this is a default without an agreement is, see how they filed, the service of preliminary declaration disclosure by petitioner. The respondent also has to file that form. So that's an indicator that this is a default without an agreement, which are the most challenging cases to get through the court, which I talk about all the time. So Not only will the fix be to start the case over from scratch, but it will be that it will be a default with agreement versus default without written agreement.